Thank you, Mr. Speaker. I rise to debate in opposition to the bill.
Lady has the floor.
And I come to you as an extreme activist for the Bill of Rights. And I want to address what the gentleman just raised with respect to this being a bill about property rights. I feel very strongly that this is not a bill about property rights. If this were a bill about property rights, it would bar entry onto any private facilities, not just agricultural facilities. But as the gentleman notes, we already have laws that address trespass. We already have laws on the book that address the protection of property component of this law. In fact, for that matter, we have laws on the books that outlaw defamation, the publication of false information, theft of trade secrets, damage to property, fraud, libel, a whole variety of underlying crimes or offenses that we would consider standalone problematic. But this is not about personal property rights. In fact, I think we can see that by looking at the text of the bill, which specifically encompasses public lands, which I think sets us apart from bills of this type in other states. I know that Utah's bill, which is being litigated, is very specifically corralled to private lands, but this bill encompasses public lands. So it's really not about protection of property, nor does it protect all property owners. As I said, it doesn't protect restaurant owners or hospitals or anybody else. It only protects one little sliver of property owners who may not even own their property. It might be public land. It's really just agricultural operators. So, I've read the AG opinion regarding the First Amendment question, but I'm of the school that, if it looks like a duck and it quacks like a duck, it's a duck. And to me, this looks and quacks like a restriction on speech. Every other component of the activity is already outlawed, as I said, but what this adds to the existing law is it adds the criminalization and dissemination of information. That's all that it adds to what we already have that's against the law. And it's very clear that the impetus for the law, the reason this law came to the floor today, is because of a desire to shield a particular group, a powerful group, the operators of agricultural facilities, from the dissemination of a particular message that is critical of agricultural operators. To me, that's per se against the letter and spirit of the First Amendment. I mean, this is specifically directed at protecting a group of people from having to deal with a message that is critical of them. Now, when you're a fan of the First Amendment, you don't look at who the winners and the losers are. You don't look at this from a question of, do I like the dairy producers better or do I like mercy for animals better? That's absolutely irrelevant. I'm Jewish, and I would fight to the death for the right of Nazis to speak. It is completely independent of message. This is about the First Amendment. This is about the right of people to get information. And so I would urge you to look away from who the parties are in this case and look at the principles of the First Amendment here. Now, we wouldn't need the First Amendment if all anybody wanted to talk about was how much they love mom and apple pie and the American flag. The reason we need the First Amendment, where the rubber hits the road, are days like today, when it's really hard, when there's a group that you really love that's getting slammed by a particular message. But that is exactly when we need the First Amendment the most. That's when it's under fire and when it's being tested. And I know that many of you folks have very close friends in the agriculture industry. I love the agriculture industry. I want them to thrive. But I don't think it can come at the expense of the First Amendment. This is not a partisan issue. Everybody is equally slammed by free speech. Now, I'm sure Obama wishes that he could have locked up the people that took the recording of him talking about people clinging to gods and guns. And I'm sure Mitt Romney wishes he could have locked up the people that made the 47% recording. It's an equal opportunity slammer, the First Amendment. So I don't ask you to think, was what happened to Mr. Betancourt unfair? Absolutely. He sounds like a wonderful man who did everything that he was supposed to do and responded admirably to this situation. But you have to address that we can't respond to that by trampling the First Amendment and by protecting him and others in that situation by insulating them from critical speech and from the gathering of information. Now, the answer to speech in our history, including speech you don't like, is more speech. The answer is to just get out there and tell your side of things. Get on the internet, get on the news, and tell your side of the story. The answer is not to imprison the people that are criticizing you, which is what this bill would do. It criminalizes the gathering of that information and the dissemination of that information. Now, is it harder in the internet age? Maybe, although arguably it's also maybe easier to get your counter story out there. But I don't think we can say that the First Amendment was a wonderful thing for our first 200 years, but gosh, now we have YouTube, so it's got to go. I think the First Amendment endures and is every bit as important today as it was at the time of its inception. So I just want to preemptively address a couple of arguments that I've heard in favor of this bill. One thing that I've heard is that it's intended to level the playing field for those in the agriculture industry, because those in other industries are able to secure their facilities better. They're able to require that their employees sign confidentiality agreements, and they're able to protect entry to their facilities that way. But it's not an equalizer of the playing field. This is criminal. I mean, if a company that wishes to secure their facilities and their information has employees sign confidentiality agreements, the penalty is civil. They can sue them if they break that. This would give agriculture the ability to bring criminal penalties for that. It gives them an incredible hammer to lock somebody up for a year if they take information that they're not supposed to take. And that is not something that those in other industries have access to. So I think, this would put agriculture in a very unique position to enforce an ability to shut down the collection of information that they wouldn't like. And it's a very unique thing that singles out an industry and, frankly, that is very specifically targeted at a particular message. This bill would also create a very anomalous situation, which I think is probably not good for the image of Idaho, where we would be in a situation where the maximum penalty for cruelty to animals would be 6 months in prison, while the penalty for recording and exposing cruelty to animals would be 1 year, double the penalty for the actual cruelty to animals. So I would ask today that you vote for the Bill of Rights and against Senate Bill 1337.
The lady from District 18 is recognized to debate this bill for the second time.
Thank you, Mr. Speaker. I just wanted to address a few of the comments that have gone by in the interim. A few people have made the comment that this would not criminalize whistleblowing, but it would criminalize the documentation of the offense scene. Now, it's of pretty limited use when a person shows up to law enforcement with just their say-so. If an employee sees an offense happening, takes a picture or video, and takes that to the authorities, I think most of us would say that's a fairly reasonable thing to do, actually, and would actually be pretty helpful to the law enforcement in terms of actually getting someone with that charge, so they're not just going on some oral statement. But that would be criminal under this law. If the person does exactly what they're supposed to and goes directly to the sheriff and says, gosh, look what I just saw happening on this farm. Here's the video that I took. There's no protection in this law if you report it to authorities versus reporting it to the media or sticking it on YouTube. It's just as criminal. You're just as likely to face a year in jail. So I would suggest that it does criminalize whistleblowers, insofar as whistleblowers might naturally make some attempt to document what they saw. And with respect to the AG opinion, I have read that, and I've read it carefully, and there are some good points in there. I just respectfully disagree in that when you're considering a law, you look also at the intent of the law. And I think the intent of this law is that the proponents don't want anybody to face what Mr. Betancourt faced, which is perfectly understandable. I agree. It's terrible what Mr. Betancourt went through. But specifically, they don't want somebody to go through a situation where a video is posted on the internet and communicated to people that reflects poorly, perhaps unfairly poorly, on the person at issue. That is what we're trying to stop, and that is speech. And so I think the intent here, it's not the videotaping. Nobody would care if there were videotaping if the videotape were buried in the bottom of a drawer somewhere. The issue that this bill is intended to address is the publication of that video. It's the speech component. That is exactly what we're zeroing in on here. And I'm not saying, and I don't think anybody's saying, that the press should ever be allowed to trespass. I agree with the AG that that's clearly prohibited. There's no special exception for journalists that they're allowed to go wherever they want and break property rights. But that's not what this bill is intended to address. We will always have trespass laws. Those are not threatened here. So again, what the specific thing that this bill adds to the entire body of law that's already out there is specifically that criminalization of the recording and dissemination of a particular message that is critical of a particular group of people. And that continues to cause me grave dismay from a constitutional perspective.
So for